Hello, everybody. This is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for participating today in this community conversation. Case law update. This is a regular program that we do about every 6 months. ECHO is a 51-year-old statewide nonprofit association. It was established or is established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. You'll find those on your screen now. These are the slide deck was sent out to all registered attendees prior to today's webinar. So take a moment just to review those very quickly, and we'll be on our way. So today we have a large audience of HOA board members. I think we have more than 200 people registered. We will do our best to answer your questions, but may run out of time. At the prerogative of the presenter, some questions may be answered during the presentation. I will also be looking at the questions, and those that I feel comfortable responding to, I will. In addition to the live Q&A session, we will answer some questions via text in the Q&A feature. To prioritize your questions, please use the upvote icon, and those questions with the most upvotes will be answered first. It's easy, simple to use the thumbs up icon in the bottom left corner of your question box. Questions button to pick your favorite questions. Those questions with the most thumbs up will likely be chosen first. Also, please keep your questions general in nature and short. We may pass over some questions that are too complicated or too long or too specific, because specific questions about your community are best asked of your attorney or another appropriate expert familiar with your situation. Please use the chat feature to report technical issues and to communicate directly with one another. We do not monitor the chat conversations for questions. Now, let me direct your attention to your monitor, where you will find our disclaimer, which reads, "None of what is said during this seminar shall be construed as specific legal advice, legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or another suitable expert." The information we provide during this webinar is educational in nature and should not be relied upon for specific decision-making purposes. Thank you for that. This webinar and all our events are made possible by the generous support of ECHO HOA professional service providers. Join me today in thanking our program sponsor, CID Consortium, LLC, our registration sponsor, Levy Erlinger and Company, LLC, and today's gift card sponsor, CM Squared. Please stick around till the end of the program for a chance to win this $50 Amazon gift card. Conrad, CID Consortium video.
HOA board members are volunteers from a variety of backgrounds who face complex legal, financial, social, and maintenance challenges. CID Consortium, LLC is proud to support educational opportunities for volunteer board members and HOA members. At CID Consortium, our purpose is to enhance your community living experience.
Thank you to CID Consortium. Please support all ECHO professional members and especially our sponsors. They make our educational programming possible at little to no cost to you. And now, on with the presentation. Louis Sarmiento Jr., Esquire, is an associate at Shearer Smith and Kinney, LLP. where he advises homeowner associations and other mutual benefit corporations, businesses, and individuals on common interest development, real estate, corporate, and general business matters. Lewis advises homeowner association boards and officers on matters including governance, development, and enforcement. So I want to say thank you to Lewis for doing this program for a couple of years now. Here you go, Lewis. It's all yours. Take it away.
Perfect. Thank you very much, Dave. So if we can, before we start, let's go into a roadmap for today. So you'll see that there are 3 cases in total. There'll be 5 bills that were enacted into law. High level, the terms of the NAR preliminary settlement terms, as well as 1 federal law. So first, you'll see these 2 here. It's Collier v. Rolling Hills. Also going into a license versus lease issue here, and Castaic Studios versus Wonderland Studios. Next, we'll go to Nash v. Apria. Discussion about the changes in the statutes affecting common interest developments. You'll see here it's virtual meetings, teleconferences, Zoom meetings and such, lowering quorum requirements, also dealing with ADUs, the assessment caps for associations that have below market rate housing, and finally the qualifications for director candidates is the last of the subject matters in the bills. Next, we've got the preliminary settlement terms and National Association of Realtors cases. We'll get into their about, and I lost count at 20, but it seems like there are more than 20 throughout the country, with allegations of antitrust collusion to inflate commissions, among others. And in addition to these lawsuits, there is a renewed investigation by the U.S. Department of Justice. So that, as you'll see here, and as we'll get into further details, the terms so far that are still subject to approval by the courts is $418 million to be paid out over 4 years, abolition of the participation rule, elimination of the broker compensation fields, alteration to the, higher use and anticipated use of buyer broker agreements, and a very large release of liability, which we'll dive into. So to our first case, Richard Collier v. Rolling Hills Community Association of Rancho Palos Verdes. Richard Collier is a homeowner. He initially sued the association, his neighbor, and several board members to prevent them from cutting trees on his property. So the question here is, does a covenant that does not appear on title for a homeowner's property apply to that property? So next, we've got the parties. It's Richard Collier. He's a homeowner and member of the association. He actually owns 2 parcels within the community. And the main defendant is Rolling Hills Community Associations of Rancho Palos Verdes. We'll discuss them generally as Rolling Hills or the association moving forward. But next, I wanted to provide a sense of scale of what we're talking about here. So Rolling Hills is a community association, but it's also a city. So for those of us that are in Northern California or even Central California, or just have not been to Palos Verdes, you may not know that there's a city of Rolling Hills that has the same boundaries as this association. The entire community is on private property, and there is no public property inside the city. So all roads are located on association easements. In total, there are 690 homes in the city, all of which are single family dwellings that are all on a minimum of 1 acre lots. And from what I can find, this appears to be the only gated city in the country. So next, for some background, in the mid 1930s, the developer Palos Verdes Corporation, or PVC, acquired a large portion of property and started subdividing Rolling Hills. So when the very first declarations were recorded in 1936. PVC carved out its first tract and recorded those CC&Rs regarding that particular section of tract that they were developing. Over the years, PVC annexed more tracts, each with its own CC&Rs. And although the original CC&Rs and many subsequent tracts contained covenants permitting the association to trim trees on properties for the purpose of preserving views, others did not. The plaintiff, Mr. Collier, owned 2 parcels outside of the original tract and had many mature trees. And in the annexation declaration that deals specifically, or that covers his property, that set of CC&Rs did not have the tree trimming covenant. So a little bit more about the CC&Rs. On the next page, you'll see that the CC&Rs were for PVC's, the developer's very first tract of land. And in the language there, it's very clear that it was intended, at least in their mind, to cover all of Rolling Hills. It stated that it established a general plan for the land, even though it only dealt with a portion of what is now Rolling Hills. It authorized the annexation of future tracts, and that those future tracts would be subject to the restrictions, conditions, covenants, reservations, liens, and charges as set forth in these CC&Rs. Again, they're called Declaration 150, but here, and I'll use that term moving forward, but Declaration 150. And the CC&Rs stated that the association's powers extended to any property or owner and owner that is in its jurisdiction. So here is the section in question that I pulled from the CC&Rs. It is section 11, article 1 of Declaration 150. Do not have to read it all by yourself. It's a lot squeezed in here, but the tree cutting covenant states in relevant part, the association shall have the right at any time to enter on or upon any part of said property for the purpose of cutting back trees or other plantings, which, in the opinion of the association, is warranted to maintain and improve the view of and protect adjoining property. So for Mr. Collier's property, further on this about background, Declaration 150M is what we're talking about for Mr. Collier's property. So again, in Rolling Hills, it consists of 57 tracts. Each tract has its own set of CC&Rs. The CC&Rs covering the plaintiff's 2 adjoining parcels did not contain the tree cutting covenant, and Declaration 150 was not recorded on his title. And this is important because when he was purchasing, he got title insurance policies. So, and neither of these 2 title insurance policies had any reference to Declaration 150, and none of his deeds, none of the 2 deeds he had contained a reference to Declaration 150. Instead, the title insurance reports reference Declaration 150M. So this all got kicked off when a neighbor asked the association to enter upon and cut trees that are on Mr. Collier's property. So next, we'll look at the applicability of the covenant onto Mr. Collier's property. The standard of review here, the court felt, was the rule of contract interpretation. So they used those rules, and as part of those rules is it's important to note that the fundamental goal of contract interpretation is to give the mutual intention of the parties, or give effect to the mutual intention of the parties. So when a contract is reduced to writing, the party's intention isn't determined from the writing alone, if at all possible. The words of the contract are to be understood in their ordinary and popular sense. The whole of the contract is to be taken together so as to not give effect to every part. So as to give effect to every part, if reasonably practicable, and to avoid a construction that would render other provisions as a surplus. extrinsic evidence, that's evidence that's not within the four corners of the agreement, is sometimes admissible. The test of admissibility for extrinsic evidence is to explain the meaning of the written instrument, where it appears to the court that there, even though it's plain and unambiguous on its face, there's evidence that's offered up that's relevant to prove a meaning to which the language of the instrument is reasonably susceptible. So next, we'll see that the court relied upon precedent in its analysis and heavily relied upon the case Citizen for Covenant Compliance v. Anderson. This was a 1995 California Supreme Court case in which the Supreme Court held that the declaration of restrictions for a subdivision does not need to be cited in the parcel's deed to be effective if certain conditions were met. So the court required that the declaration be recorded before the execution of contracts for sale, that it describe the property it is to govern, and to state that it is to bind all purchasers and their successors. The court reasoned that if the restrictions are recorded before the sale, the later purchaser is deemed to have agreed to them, even if there's no additional reference to them in the deed. So as a sidebar, this is one of the reasons why it's very important to for buyers to obtain title insurance, because deeds do not always include reference to restrictions or easements that tie up the property. So here, as we discussed, the tree cutting covenant did not apply to Collier's properties, and Declaration 150 did not describe Collier's property and was outside of the chain of title. So in this case, the court found for Collier that the covenant was inapplicable. So next we'll see what the implications for CIDs are. CC&Rs and covenants included in CC&Rs or implied agreement. Developers and associations record the obligations and buyers accept them as to the terms through purchasing their property. But please note that the terms must be recorded in a way that can be easily found for all buyers, so that they know what they are purchasing. So the burden is on the developers and the association to insert the covenant and restrictions into the record in a way that it can be easily found. It's important to note here that there's an unpublished portion of this award, and there was a discussion about attorney's fees, and I won't get into it here since that portion was not published and it's not precedent, but it's important to note that the party should avoid the perspective that they'll get into a lawsuit and then, since they're right, they'll get their attorney's fees back. For illustration, the trial court, the lower level court, awarded a reduced amount of $1,328,000, again, reduced amount in attorney's fees against all defendants. I say reduced amount because that means that their fees were higher than $1.3 million. And the Court of Appeal actually vacated the trial court's attorney's fees award and directed the trial court to enter a new award for attorney's fees. I'm thinking that that new order would likely be zero based on the discussion, but the parties bore their own cost on appeal as well. So in addition to the parties, I think likely are going to be having to share their own cost, or sorry, bear their own costs as part of the trial court proceedings. They were required to bear their own costs on appeal. So please know, attorney's fees are not guaranteed. Please attempt pre-litigation ADR. So next, Castaic Studios LLC versus Wonderland Studios LLC. The question is whether a license agreement can be enforced with an unlawful detainer action. So as a general note, an unlawful detainer action is a remedy that's available to a landlord against a tenant who breaches the lease and is intended to it is intended and designed to provide an expeditious remedy for the recovery of possession of that real property. This is being included in this case law update, as I presume there are a number of CIDs throughout the state that utilize license agreements instead of leases. your CID's legal counsel can go over the benefits of one or the other for your association, but two benefits, or at least perceived benefits that exist, or that they can be drafted as revocable, and that it has the purpose of attempting to avoid protections for tenants in many cities and in the state. So, as I mentioned, the parties here, Castaic Studios, they are the commercial licensor. They run TV and motion picture production company, as well as, according to its website, its studios has 6 full stages, and its customers include Netflix, Hulu, and HBO. Wonderland operates its own production company. On its website, it claims over 181 square feet of production space and over 50,000 square feet of interior space over 80 acres of land. So for background, Castaic owns this commercial property in Castaic, California, Castaic Studios rather. And in October 2021, Castaic Studios entered into a license agreement with Wonderland, under which Castaic Studios granted Wonderland the exclusive but not possessory right for the use of property, with the exception of stage area and storage building. The agreement afforded Wonderland 35 consecutive 1-month options to extend. And to exercise these options, Wonderland was required to timely make all payments owed and to send Castaic a letter of intention of the extension of the term for the next period, at least 20 days before the end of the current month. So in July 2022, Wonderland was in default of the payments owed, and they failed to timely send a letter of intention to extend the term for August 2022. So Castaic alleged the agreement expired by its own terms. But on July 13th, Castaic sent Wonderland an email notifying them that it was in default, but Wonderland attempted to exercise their option and extend for an additional month. Castaic alleged that it did not serve notice on Wonderland because the agreement expired on its own terms, and that Wonderland failed to timely notify Castaic of its intention for the August 2022 option. So next, for additional background, the language of the license agreement was pretty clear that this was intended to be a license agreement, not a lease. We've got section 6 of the agreement saying that this agreement is not a lease or any other interest in real property. It is a contractual agreement that creates a revocable license. The licensor retains legal possession and control of the premises. Licensor has the right to terminate this agreement due to licensee's failure. Section 12.1 says licensee is in default if licensee does not pay the required amount payable here under. Section 13.3 provides that if Wonderland defaults, Castaic may immediately terminate licensee's right to use the premises by any lawful means, in which licensor's obligations under this agreement shall immediately terminate, and licensor shall have the option immediately to take over use of the premises from the licensee. And finally, section 29 provided this agreement will be governed by contracts laws and not by landlord-tenant laws. Seems pretty clear to me. So the trial court in August 22, 2022, Castaic filed an unlawful detainer action seeking possession of the property and for unpaid rent, or what Castaic called unpaid rent. Wonderland objected on the grounds that the agreement expressly stated that it was not governed by landlord-tenant laws, and that the 3-day notice Castaic served on Wonderland did not contain the statutorily required language. So after a briefing and hearing, the trial court sustained the demur, the request to dismiss the case, without leave to amend, relying on the sections that I quoted, that this is a revocable license, this is not a lease, and that the governing law is contract law, not landlord-tenant law. And the court concluded that Castaic had waived its right to pursue the remedy of unlawful detainer. Again, on the next page, we'll go into the pertinent law being contracts law. So Castaic asserted that the trial court erred in sustaining Wonderland's demur without leave, arguing that despite the express designation of contract law and the disavowalment of landlord-tenant laws as the governing law, the agreement did not prevent Castaic from resorting to the proceedings of an unlawful detainer. And while discussing the pertinent law, the court stated the rules of contracts interpretation, and those rules essentially state, one, that the court should honor what the parties mutually intended at the time they entered into the contract. Two, when a party is clear and explicit, look to the language of the agreement to determine what the parties intended. And three, the words of the contract are to be understood by their ordinary and popular sense. So next we'll see what the Court of Appeal, they concluded that Castaic waived any right it may have to bring the unlawful detainer action against Wonderland. The trial court's judgment in dismissing Castaic's claims was affirmed, and Wonderland was awarded its costs on appeal. Again, the court looked at this very explicit language that said that this is not a lease or any other contract interest in real property, and it is a contractual arrangement that creates a revocable license. So what are the implications for CIDs? Courts give weight to what parties say in contracts. The license agreements are not enforceable via unlawful detainer action. Certainly, again, if your CID uses these, please do speak with counsel, make sure that it makes sense for here, or that when it comes time to enforce these agreements, they should be looking at and following through and enforcing it, not through an unlawful detainer action, but through contracts law. So next we've got the case Nash v. Apria. Question here is, do contractual attorneys caps on awards for attorney's fees apply to awards for attorney's fees incurred to enforce the underlying judgment? So we'll get into it, but it does say, I understand it sounds like fees on top of fees, which is actually the case here. So we've got the parties, Thomas Nash and Bo O'Connor. Here we'll either just refer to them as Nash. They are the residential tenants, and the residential landlord and defending here is Nilan Apria. So for background, Nash and Apria entered into a written residential lease agreement to rent a home in LA for 6 months. During that tenancy, Nash and O'Connor discovered mold on the premises, and they came to an agreement with Apria to receive a credit for 1 month's rent. At the end of the term, Nash and O'Connor vacated, but Apria did not pay the agreed upon credit. They did not return the security deposit, and they did not ID the deductions from the credit or deductions from the deposit. So next, the discussion at the trial court level. At the trial court level, they found that there was a default judgment for Nash. So Nash and O'Connor filed a proof of service for a summons and complaint by substitute service at Apria's house. Apria did not file the answer, and Nash and O'Connor filed a request for entry of default or a default judgment. And in that matter, because Apria did not respond, she did not provide an answer, the court found in their favor, and the plaintiffs subsequently filed a request for a judgment and an award in the amount of $59,000, consisting of $56,000 in damages, $1,500 in pre-judgment interest, as well as $1,000 in attorney's fees. So that was the cap that was explicitly listed in the agreement. So the trial court entered that default judgment against Apria for the $59,000, which included only that $1,000 in attorney's fees and a bunch of costs. But there's back and forth. Apria filed a motion to vacate, and that got thrown out. But so there was a question as to attorney's fees. Please just for context, the Court of Appeals determined that the attorney's fees are, well, as for context, attorney's fees are generally paid by each side, but they're recoverable when they're authorized by contract, statute, or law. So you'll see this in CC&Rs or in the Davis-Sterling Act, which it explicitly states that the party who is enforcing the terms of CC&Rs or governing documents may be awarded their attorney's fees as part of that enforcement. But without explicit authority via contract, CC&Rs, or other statute, then the default rule is that each party pays its own attorney's fees. So next, while the court determined that the default judgment was appropriate and gave attorney's fees to Nash and said that APRA was responsible for attorney's fees, APRA actually did not pay those attorney's fees. So Nash's attorneys filed an action and tried to get fees that were incurred in enforcing that judgment. Again, the default judgment that was awarded to Nash. And the Court of Appeal mentioned that there are two requirements for the recovery of attorney's fees and a judgment cost. One is that the fees must have been incurred to enforce the judgment, not defend. And two, that the underlying judgment had to include an award for attorney's fees pursuant to a particular statute. Again, so here it was the attorney's fees to enforce the award that the court had already given to Nash and O'Connor, but because APRA did not pay that initial award and as it was required, there are these post-judgment attorney's fees that are incurred for the purposes of enforcing the award. So I do want to talk about that cap in the lease. It was a form that was published in the California Association of Realtors form, and it was titled Attorney's Fees, and it stated, in any action or proceeding arising out of this agreement, the prevailing party between landlord and tenant shall be entitled to recover reasonable attorney's fees and costs collectively not to exceed $1,000. So APRA saw this piece and said, well, if these are attorney's fees that are sought for the purpose of in a suit that arose out of this agreement, it should be capped at $1,000. The court noted that this is a superficial appeal. If Nash and O'Connor were authorized as prevailing parties in the underlying action to recover only $1,000 in attorney's fees, why should they now be able to recover almost 30 times as much in the enforcement action as judgment creditors? The court ultimately determined and followed the precedent that said that the judgment at the trial court extinguished all further contractual rights, and that included the contractual attorney's fees clause. So next, the decision is that the judgment was affirmed. Nash was entitled to recover attorney's fees at the trial court and on appeal. So the implication for CIDs, we'll see that attorney's fees can be imposed in post-judgment awards. So please do pay the ordered awards. Again, the CC&Rs do have that enforcement action, prevailing party attorney's fees. I know that it is certainly a piece that is demanded as part of letters that go, in both directions. But if it does get to a point where your arbitrator or judge determines that you were the party that isn't required to pay the others the attorney's fees, be mindful that the enforcement, the attorney's fees incurred on the enforcement can also be levied upon you. So next we'll go into the changes in statute, or certain changes dealing with virtual meetings, quorum, accessory dwelling units, and others. So first is AB 648. Board member board or member meetings may be conducted entirely by video or conference calls, except for meetings where ballots will be counted. So I know over the last 4 years, everyone's gotten used to having conference calls. But here, the law made it clear that it can be entirely by conference calls. The notice must include clear technical instructions on how to participate via teleconference. There must be contact information for a person who can provide technical assistance before and during the meeting. And there must be a reminder in the notice that a member may request individual delivery of the notice. The directors and members must have the same ability to participate in the meeting as if it were held in person. And that any vote of the directors must be held by a roll call vote. So that is to avoid the possibility if there being uncertainty as to who voted in which favor. So in a roll call vote, the parliamentarian or the manager or the person that's actually directing traffic would ask each director what their vote is. And eligible voters must be given the opportunity and option of participating by phone. It must not entirely be via video conference. It must allow for that option to participate by phone. So next, AB 1458. So quorum, if it is needed in the election for the election of directors, will be reduced to 20% of the CID's voting members if quorum is not made on the date of the scheduled elections. So please, Inspector of Elections or any community association managers in attendance today, please review the statute to see what has been added to the pre-ballot notice. This lower threshold would apply for any CIDs whose governing documents require a quorum to elect directors, and assuming that the threshold is higher than 20%. I know we're all aware that how difficult it is to get a quorum at meetings, but this should help in that process to alleviate that issue if at the very first meeting on the date on which the ballots are to be counted, or at least determine whether or not there's quorum, that there's a process so that at a later date, the hearing, the counting and tabulation can be done at a later date with a reduced threshold of 20% of the voting power. Next, AB 1033. Many pieces here, but most pertinent is that it requires local agencies to allow ADU be sold separately from the primary residence if there are certain conditions applicable. It allows local agencies to adopt a local ordinance to allow the separate transfer of ADUs from primary residence, and the mechanism for allowing an ADU to be separately transferable would essentially be a subdivision of the lot and the creation of the condominiums. But it's important to note that on the next slide, we'll see that if there's an owner within an existing planned unit development if they sought to subdivide their lot for ADUs, there must be express written authorization from the association. And again, I'm saying planned unit development because this would not apply for condominium communities or stock co-ops. And the written authorization by the existing association means approval by the board at a duly noticed board meeting, and if needed, pursuant to the existing association's if it is required under the governing documents, that the membership approval of the existing association would also be required. So if you're in a planned unit development and your association wants to avoid or otherwise regulate the subdivision of lots, please consult with an attorney to find out exactly what your governing documents permit. Next, AB 572. This prohibits a common interest development that records its original declaration on or after January 1st, 2025 from imposing a regular assessment increase on owners of below market rate units that is more than 5% of 5% plus the percentage change of cost of living with a cap of 10%. There are exemptions. Please see the statute for those exemptions. But again, this is dealing with regular assessments. It leaves special assessments untouched. Next, AB 1572. This prohibits the use of potable water, drinkable water, to irrigate non-functional turf on HOA and other CID properties beginning January 1st, 2029. Association's got 5 years to make those changes. Next, AB 1764. So the Davis-Sterling Act provides procedures governing the election of members to the board. And the existing law authorizes the association to impose certain qualification requirements, including requiring a nominee that has been a member for at least 1 year, or disqualifying a nominee for a past criminal conviction. Under this law, an association that disqualifies a nominee pursuant to either of those items would be required in its election rules to require a director to comply with the same requirements. Again, if the board were to say, well, we can disqualify a nominee, non-director candidate, those same rules have to be carried over to incumbents. So also, if there are not more qualified candidates than vacancies, the association is authorized to consider the candidates elected by acclamation if the association permits all candidates to run if nominated. So previously, an association was authorized to disqualify a nominee who has served the maximum number of terms or sequential terms, but this bill instead would require, instead of allowing it to do so at its own discretion, this bill requires the association to disqualify that nominee. And finally, a director who ceases to be a member of the association would be disqualified from continuing to serve as a director. Seems common sense. Surprised this wasn't in the law already, but that's the case to make that clear. So next, we'll get into the National Association of Realtors Commission cases. Again, greater than 20 lawsuits throughout the country. There are allegations of antitrust and collusion to inflate commissions, among others. And there are at least 22 class actions, 2 lawsuits not involving a class plaintiff, and the DOJ investigation into the NAR. So at the very high level, the allegations are collusion to inflate commissions. As to that, the lawsuits allege that the NAR and major real estate firms colluded to artificially inflate real estate agent commissions, which in this country are among the highest in the world. Second allegation dealt with anti-competitive rules and practices. So the lawsuits challenged NAR's participation rules that required the sell side agents to make an offer of compensation to the buyer's agents, which are seen as a way to inflate the commissions. The lawsuits also challenged the NAR's rules that required the display of broker compensation on the multiple listing services, MLSs, and mandated the buyer's agents to be compensated through the listing broker, the seller-sided broker. There were allegations, third, of the lack of transparency. The lawsuits allege that the real estate industry lacked transparency around broker commission, and that prevented consumers from being fully aware of the fees they were actually paying or not paying. Fourth, the restraint of trade. The DOJ filed an antitrust lawsuit alleging that the NAR established and enforced illegal restraints on how realtors compete. So one concern was that certainly certain larger brokerages required their agents to be members of a NAR or realtor association, more local realtor association. There certainly is the concern that in order to use MLS, larger ones rather, you have to be a member of the National Association of Realtors. And there was also a concern that lockboxes, many of the lockbox companies require you to be a realtor as well. So that has its problems. The DOJ sought to require the NAR to increase transparency around the buyer broker commissions and to eliminate the rules that limit access to lockboxes. So next, the preliminary settlement terms. Note that they're still pending court approval. The terms include $418 million to be paid out over approximately 4 years. The end of the participation rules, which again require the sell side agents to make an offer of compensation to buyer's agents. Elimination of the broker compensation fields. All fields that display the broker compensation in the MLS must be eliminated. And I actually just checked yesterday, and I still see the commission and compensation listed in an MLS that I checked. And there's still the blanket ban on the requirement that buyer's agents be compensated through the listing broker. On the buyer broker agreements, buyer's agents must now enter into a written buyer broker agreement directly with the clients rather than having the compensation baked into the deal. And then finally, as to the release of liability for the NAR, over 1 million NAR members, and all state, territorial, and local realtor associations were a part of the release, with carve-outs. All association-owned MLSs are part of the release, and all brokerages with NAR member an NAR member as a principal whose residential transaction volume in 2022 was $2 billion or below were released. So the next steps. Certainly there are the practice changes. The practice changes, which are to go in effect by mid-July. Well, we still have this preliminary decision or the decision on the preliminary approval. Courts still have to provide their input there. There's the practice changes, which have the prohibition on the offers of compensation in the MLS. Once that change goes into effect, the consumers would have the option to pursue offers of compensation off the MLS through negotiating. And practice change also includes the MLS participants working with the buyers to enter into written agreements with their buyers. And I should say, as a real estate attorney that also happens to be a licensed broker and a realtor, I had always found it odd that there weren't written agreements that were already in place. Again, with the broker side, the buyer broker side, I think this would be a great move forward in making the terms of the representation clear. And certainly when it comes to compensation, and many buyers are either explicitly or understood that they weren't paying for their services, at least not directly, but of course it's baked into the price. So I think it's a great move that moving forward that would be much more transparent. And notably, the preliminary settlement does not address all filed litigation, as the lawsuits involving those home buyers who were not part of a class, they're not impacted, and those larger brokerages are not included in this release. Next, that was pretty heady. I know next we're going to dive into the Corporate Transparency Act. Almost done. One last subject matter. So the Corporate Transparency Act, it requires all CIDs, among others, to report beneficial owner information with the U.S. Department of Treasury. It was federal law that was enacted in 2021, but went into effect on January 1st, 2024. So who does this apply to? This applies to domestic reporting companies as well as foreign reporting companies. Domestic reporting companies include LLCs, corporations, and other entities formed through filing with a Secretary of State or a comparable office in the United States. And the foreign reporting companies are those that are registered to conduct business in the United States, again, through filing with the Secretary of State or an equivalent office. So most CIDs would qualify as a domestic reporting company because they're either nonprofit mutual benefit corporations, or they're stock cooperatives, or they're entities that are formed through a filing with the state. This would, if you are an unincorporated association and you did not file with the Secretary of State at your formation, this might not apply to you. But again, please do check with counsel, because I am aware that there are unincorporated associations that still do file with the state to let the Secretary of State know that it is an unincorporated association. It's unclear if that filing would trigger the requirement. So who else? Well, rather, let's talk about who this does not apply to. There are 23 categories of exemptions. The most pertinent one here from the beneficial ownership information reporting requirements are those entities that are tax exempt entities. So please note that these are only for, this would only apply for CIDs that have tax exempt status with the IRS as a 501c entity. This is not the same as being a nonprofit mutual benefit corporation. If you're a nonprofit mutual benefit corporation, but you are not recognized by the IRS as having tax exempt status, this still applies to you. So what is required? A beneficial owner is an individual who either directly or indirectly exercises substantial control over the reporting company, and two, owns and controls at least 25% of the reporting company's ownership. So per the feds and an FAQ, they do get into what is substantial control. An individual can exercise substantial control over the reporting company in one of four ways. Either they're a senior officer, they're an individual who has authority to appoint or remove certain officers. Either they're an individual that is an important decision maker. They don't get into detail what an important decision maker is. And finally, they're an individual that has any other form of substantial control over the company. Again, not the clearest. But when it comes to ownership interests, that again, I know we were talking about CIDs. Certainly, it's much more clear for stock cooperatives, but if you're a common interest development and there is a percentage of ownership that is attributable to one particular owner and they own 25% either of what can be considered to be the equivalent of 25% of the CID's ownership interest, then it would seem to satisfy that second piece as well. And certainly I should say the full name of CID, and I know I'm using the term, it's common interest development. Common interest development, as you all may be aware, includes HOAs, but because common interest developments apply to other types of entities, I'm using the term CID or common interest development more generally because it does apply to more than just condominiums or HOAs. So where can an entity report? If you're required to report your company's beneficial ownership information to FinCEN, you'll do so electronically through a filing on the website. It is, as you can see here, or sure, a search will pull it up, but boiefiling.fincen.gov. So when to report? So if you were a company that was created or registered to do business before January 1st, 2024, you have until January 1st, 2025 to file your initial BOI report. If you are a reporting company that's created or registered in 2024, you'll have 90 days to file after receiving actual public notice that of its creation or that the registration is effective. For reporting companies created or registered after January 1st, 2025, it will have 30 calendar days to file. But also, if there's any change, if there is any change to the required information about the company or its beneficial owners, in the information that was provided in the beneficial owner information report, then that would need to be updated no later than 30 days of the date of the change. So why? The Corporate Transparency Act was enacted to combat money laundering, tax fraud, and other illegal activities that require certain businesses to disclose this information as a way to try to combat those items. But really, there are fines, and that's why they're being included, and that's why reporting entities should comply. As it's specified in the Corporate Transparency Act, a person who willfully violates the beneficial ownership information reporting requirements may be subject to civil penalties of up to $500 each day that the violation continues. That person may also be subject to criminal penalties of up to 2 years imprisonment, as well as a fine of up to $10,000. Not sure how that apply or the extent to which the hammer will be brought down on a common interest development, but that's the law. Those are the fines that they could go up to. So that is the end of my presentation. Certainly wanting to address any questions that might be applicable to the group.
Okay, so let me go ahead and break in real quick here, Louis.
All right.
We're gonna be moving into the Q&A session. I have a couple announcements. So first of all, I want to remind everybody to use the thumbs up icon in the Q&A feature to place the questions you would like first answered in the first position. And then there is a little caret, a little down arrow, Louis, you can see in your in the feature, the Q&A feature.
Okay.
Pick the most upvotes. That'll bring in the most there.
Got it. Okay. Got it.
If you see it.
Yep.
Okay, and then we can go ahead and answer the questions. Thank you so for your presentation. We'll go ahead and start now.
Sure thing. So one question is, are roll call votes also required during hybrid meetings? Without the statute in front of me, I don't know if they're required during hybrid meetings. But if there are folks that are either on the phone, or the directors or voting parties are either on the phone or on a teleconference, it would make sense to call out each person, say, you know, Director Zapponi, how do you vote on this? You know, Director Sarmiento, how do you vote on this? To avoid the situation where the vote is just straight up yay or nay, you know, how many people raised their hand, that just so it's clear who voted in which way, so that the meeting minutes can clearly reflect the number of votes, the number of abstentions, and you know, whether or not there are adequate votes for the approval. So next question, if a meeting is for counting votes, does the election counter have to be present at an HOA meeting, or can it be viewed online? It does not state that it cannot be done online, and it doesn't state that it necessarily needs to be at a present meeting at which everyone can be there. So as such, I think it would default to the rule that everyone used over the last 4 years of, it would make sense to have a physical location at which the meeting takes place. And that inspector of elections is you know, present with the camera on them, showing them that that the opening of the ballots and the counting of the ballots, opening of the envelopes rather than the counting of the ballots happen on screen. So again, to your question, it doesn't say that it cannot be done. It's just that it cannot be done entirely via teleconference. There has to be that physical location that's listed, and that people have to have the opportunity to view the inspector of elections, though it's ambiguous to say how they view them.
So the next question is about the inspector of elections as well, and I'm going to just cut to the chase here.
Yeah.
Is it okay to have the property manager or community manager assist by preparing and mailing the ballots and balloting material to the voters? Are they adhering to the requirements of having an independent inspector of elections if they allow that to happen?
The answer to that is dependent on the statute. There are a number of things that the inspector of elections can delegate, and there are a number of things that statute says that the inspector of elections has to do it. So can't say that off the top of my head, just based on the fact that statute specifies what the parties are to do. But though I am aware that many managers assist, or rather, Inspector of Elections delegates these tasks to others. It really depends on what the statute says as far as what are the particular requirements that are being delegated or, being done with the assistance of property management.
Yeah, and just one other comment from my chair as a non-attorney. Remember the optics when you're doing this. If you're in a contentious community, just remember that try to keep things as up and transparent as possible. If it can be construed as being nefarious or trying to put your finger on the scale, that's if you have somebody like that in your community, then you got a problem. So make sure that you stay clean on that as a practical matter. Yeah.
Right. I advise the boards that I'm working with on ballots to have the board approve the ballot question. In addition to making sure that legal counsel reviews it, but so that even if the Inspector of Elections or the property manager prepares the ballots, I think it's important to make sure that that question is valid. And that it meets all requirements so that perhaps the manager actually mails them and maybe they assist in typing it up. But I think it is important that the ballot itself is appropriate and legally enforceable. Because at the end of the day, it's all about enforcement of the ballot question. And if it's an improper ballot question or it doesn't really get to the heart of what's being done, then that might cause concerns for the association.
Okay, so you may have answered this one earlier. I got distracted. In a virtual board meeting, does a member have to be on camera, or does it matter?
They do not need to be on camera. It could be via teleconference, but if it is, but the situation that the law tries to avoid is where everyone has to be on camera. So if the virtual meeting is set up in a way that everyone has to be on virtual camera and there's no dial-in option, that would be problematic under the law. So to the question, no, not everyone has to be on a meeting. I'm sorry, on camera. But on the flip side of that, you can't force everyone to be on camera.
Okay, but you have to make it available via telephone or
Correct.
otherwise
Right.
to somebody in the community.
Exactly. If somebody wanted to dial in, they should be given the option to dial in.
Okay, and Barbara Robinson, does the 20% quorum bill overrule any higher quorum requirements stated in the governing documents?
Yes, it does. And again, it would kick in on that second meeting. So if there is an election that's scheduled to take place and the ballots to be counted on one date, if there is greater than 20 but less than whatever the quorum that's stated in the governing documents, then it won't go as far as counting on that first meeting. But after following the requirements in the statute, then that 20% quorum or that 20% can be used as quorum for the second meeting, the one where the ballots are actually opened after noticing to the community that this will be delayed.
Mm-hmm. Well, Carol has an interesting practical question. When you're holding a virtual meeting and people decide they won't use the camera, but they call in, how do you know that the people that are calling in are actually the homeowners?
I don't know how I mean, I'm sure the board can come up with a policy or the association can come up with a policy. Especially when it comes to the open forum piece. But yeah, that's true. It is difficult to say if it is entirely virtual, someone dials in on an unknown phone or an anonymous phone. It could be someone who's not a member, or it can be, someone's legal counsel. But again, and remember, the concern is that this just be transparency, and that members have the opportunity to see what the board is doing, assuming this is a board meeting. But if this is a member meeting and the members have to vote, I imagine the board and the manager and legal counsel might come up with a policy to confirm who people are if there is a vote to take place. I think it's more about validating those votes and authenticity of those voting. If it is a meeting at which everyone's going to be present in a virtual meeting and try to call in and have a meeting take place. So it goes to a policy, I think, that the board should adopt, or the association should adopt for the policy.
Okay, well, Alpa has a question here. The Corporate Transparency Act. I've heard that this may not likely or is not likely to become law. Any thoughts on that? I know that there is some work that's being done.
Yeah, so currently it is a law. It was enacted in 2021, though there are challenges in the courts. And currently the challenge in the court, I believe, is in Alabama. So, you know, maybe it goes through the court, maybe it gets appealed, but for now it is the law. You know, until Congress comes up and adopts a different law, or until it makes its way through the legal process and it gets overturned, until that time, it is a law, and it is the requirement that applies.
Yeah, I believe the federal district court in Alabama said it was unconstitutional, but that's only in that jurisdiction.
In that jurisdiction, right?
Yeah,
Right.
and so it's possible that it could be tried in the Ninth Circuit Court and or in our district, a federal district, and the same outcome could come.
Right.
They can rewrite it, or there's ways to get
That matter has a ways to go because they filed in Alabama. They didn't file in federal court, to my understanding. And
Okay.
if they filed in federal court, then there might be a way to bring it up to the Supreme Court, or at least because it's a federal law, then application of this in federal court is how it might be trickled down to everyone. But for now, again, I think everyone has to assume that this is the law of the land, and that it is how it is in effect right now, and until, like any other law, until it gets repealed or unless it's proved to be unlawful, it is the law. And I think those in California should plan on submitting before the January 1st, 2025 deadline. And as that follow-up question that's there, I don't have a crystal ball. I can't say whether or not the law will be overturned by the 2025 deadline, but I think it would be important to follow the law as it is currently.
Okay, our board is relying on our accountant that we do not qualify. And is that a reasonable expert, or does it need to be our attorney? That's for the CTA, so.
Yeah, I guess I'm not sure as to what the question is as to that we do not qualify.
So they don't qualify to have to fill out the Corporate Transparency Act documents. So their accountant is telling them, you don't need to do that. Are they considered qualified to make that determination? So they rely on them to not fill it out.
Right. That is a decision for the board to make, and to just determine whether or not they think the accountant has enough information to give them the information that the board needs to make its decision.
Yeah, to be safe, you probably want to
Yeah.
run it by your attorney anyway, right? So this is a tough one, and the fines are pretty high.
Yeah.
Not to mention, I believe there's jail time that could potentially happen.
Potentially, yeah.
Not unlikely, but potential. Okay. So don't mess around with this one. Okay, so let's go to Vicky. We have 5 board members. So if 3 members agree on a date for a meeting, isn't that the quorum? And so a meeting should happen. You're talking about a board meeting here, Vicky, I assume? Okay.
So I think the question relies upon the practice currently, where people say, all right, well, the meeting is to take place on April 21st. We are a few days away, and we are nowhere near exactly what the quorum is. And at that time, the inspector of elections can look at what's in hand and recommend that date be pushed out. And I've certainly seen this in many associations and CIDs where they say, oh, well, let's hold the date at which the original meeting takes place to be 30 days from now or 60 days from now. If that does get put into place and that original meeting gets pushed out, then the quorum wouldn't apply because you technically never had that first meeting. But still, if you were 2 or 3 days out and you look at the ballots you have, you cannot automatically apply that 20%. You have to have that first meeting. And then you have to allow for additional ballots. You have to provide the notice that there will be a later date at which the ballots will be counted. So no, you can't jump the gun and say, well, we're way under, so we're just going to have a meeting and use 20%.
Okay, I think that answers Marcia's question as well, the next one there. Clarification, can this all happen without actually conducting in the original meeting? So you have to have the meeting first and
Right.
then you can
Go through the notice requirements and follow the other conditions before you have that second meeting. And that's at that second meeting where the lower quorum threshold would kick in.
Okay, so let's move down to Alpa's question about Collier. Did Collier get off on a technicality? Sounds like it.
No, I don't think it's a technicality. I mean, they, it's contract. If Dave, you come to me and say we entered into a contract and I owe you $1 million, and I say, hey, I didn't sign that. I never agreed to it. It's almost the same thing here. The covenant rather, was never part of the chain of title, and for property, for easements, we're talking for CC&Rs. When you purchase, you do your due diligence, you get title insurance, you go through all that and say, well, great, these are all the conditions to which I would take the property subject to. And if I decide to buy, then you're buying with the opportunity to know at least that you're buying subject to all those terms. So if the CC&Rs or the condition was never on title, I mean, yeah, I guess technically it is a technicality because it was never in chain of title, but the homeowner couldn't be, and homeowners here can't be held to a covenant that they never agreed to, even implicitly by purchasing subject to that condition.
Okay, so thank you for that. There's a rather detailed conversation going on here from Anonymous. She asks if the manager announces that a meeting is going to be recorded, is that first legal? And if legal, can the homeowner also record it? And then Jennifer responded to that, and you can read. It's
Right.
really lengthy. I don't know if you want to do that or follow that. We can go to.
So this goes to the California Penal Code that ultimately says that there cannot be surreptitious recording. And this is also why if you call 1-800 number, they always tell you for providing service and being able to go back to, we're recording this meeting, that notice has to be there, that it is being recorded. I mean, I guess if homeowners record after the fact, that's an argument, I think. Can't say it is legal, can't tell you right now it is illegal. But the consent piece of being informed that there's a recording gets the concerned party out of the violation, or that there was a surreptitious recording, that there was an unknown recording of a party. And I guess to the follow-up from Jennifer, the recording camera. I would not advise any board to have a secretary record meetings, but not tell people. I understand that many boards do record meetings for the purposes of supplementing their information and their notes for when recording, when preparing and reporting the minutes. And I'm also aware many CIDs have a policy of deleting it after that time period, but it should still, the board or the secretary should put a notice to the members that it is being recorded so that they are aware and can act accordingly.
Okay. And then Carol, I think asked the same question that was answered earlier, 1458, AB 1458. If the CCNRs provide for a reduced quorum, but it's higher than the 20%, say 33%, which one has precedence?
20%.
20%.
Yeah, I assume that means that initially those CCNRs say that it's 50% and then it would step down to the reduced of 1/3, but under AB 1458, it would be down to 20 on that second meeting.
Okay, so we're down to all the single questions here. So we have about 15, we have about 13 minutes left to go here. So I think what we'll do is we'll take one more question, and then we'll go into the final. And then if we have time after our final announcements, then we'll pick up a couple more to conclude at 2:30 as promised. Okay. So let's go ahead and let's take anonymous attendees. Lewis, excellent presentation. How much time did you put into preparing the PowerPoint? And this is the easy one, PowerPoint, verbal presentations, etc.
Over 10. Certainly had to get into the cases. Many of these cases are either not in other people's presentations, and it's been 6 months roughly since the last time I did this for ECHO. So it's diving into not only the Davis-Sterling Act and the cases that are directly referencing the Davis-Sterling Act, but also looking into real estate cases. So
yeah, it's really appreciated the time you spend on doing this. And this is why attorneys get paid so much money too, is because they have to continually learn and learn and learn. Right. And so this happens quite a bit. So let's go ahead and I'm going to pull up my final script here. We'll go ahead and conclude the meeting. Thank you again, Lewis, for your participation today and putting in those 10+ hours preparing the list of cases. That's very much appreciated. I want to thank everyone of you, the ECHO members, for coming today and supporting our ongoing educational efforts. And for those of you who are not ECHO members, if there are any of you out there, please consider becoming a member and supporting HOA boards throughout the country. To join, simply go to www.echo-ca.org and click on the membership tab. We'd love to have you be a member. In fact, I just got a call yesterday from someone in North Carolina. So we have members all over the country now. For ECHO members, thank you for supporting us, and please invite your friends, boards, and especially your management firms and vendors to join ECHO. We would welcome them aboard, and it's great for them to help support us and you in your endeavors. A simple invitation is often all it takes to encourage a member to join ECHO. If you would like to become more involved with ECHO, we have a few opportunities available. We're always looking for volunteers. We're running some events coming up, and we'll talk a little bit more about those. We can always use someone to help at the door or help set up or take down, things like that. Please refer to the slide. If you see anything that looks interesting, please send me a note at dzapponi@echo-ca.org. And now for our other announcements. This year, ECHO is launching a new educational program focused on HOA board preparedness. The core curriculum of 10 courses is designed for high-quality training and is available for HOA board members, interested homeowners, and for professionals. Your participation in this program will earn you a certificate of HOA board member preparedness, or BMP. The courses will initially be offered live via webinar with 8 of the 10 courses recorded, so you can listen to those at any time. If you miss a live program, the course will be offered on demand as a recording. If you or someone you know wants to enroll in the certificate program, please send an email to Connor. He'll set you up. His email address is on the screen. And in 2024, the 2024 resource panels have entered the second quarter now. Tomorrow, we're going to have the San Diego Resource Panel, followed by the Wine Country, North Bay, and San Francisco panels at the end of the month. If you can participate in any of these events, we look forward to seeing you there. You can register for them online. Echo is planning 3 larger events this year. We are planning these now, and you'll have more information about them a little later in the year. We have two interesting programs coming up. We have one in San Jose. It's going to be at the Villages community in San Jose. The Villages is going to have our educational seminar in person. We'll have tabletops there. Senator Dave Cortese has interest in participating in that, so we're hoping he'll be there. He's on the Senate Housing Committee. And then we're looking and talking with FireSafe and FireWise, NFPA's FireWise program, to try to help find some solutions in armoring your neighbors and your communities. So we hope you come to see us at that event. That's going to be on June 22nd. And it'll run roughly from 9 until 1 or 1:30 in the afternoon. And please sign up. We are going to have an early bird sign up, and it'll be free. So we want to make sure we get a good number of people so we can pack the room and make sure the senator feels welcome if he confirms. Once again, I want to say thank you to all of our sponsors for making this community conversation possible. And thank you to Lewis for developing and presenting the materials. And of course, I want to say thank you to all of you for attending today and making this a successful event. Echo appreciates your investment in education to foster a better quality of life in HOA communities.